agree with Justice Alito.
I do not.
So we can only make that inference if 100% of cases are eliminated.
If you look at the statute and you look at you look at the FSIA and you look at Title III.
No. Forget about the FSIA. We've dealt with that.
Mm-hmm.
We're just dealing with what's required to abrogate sovereign immunity. And you're saying, okay, you can either use the magic words or you can create a cause of action that would completely be useless otherwise.
Correct.
0% of cases.
That's right.
You agree with those two things?
I do.
But once we get to 99.9% of cases, you say that same inference is unavailable.
Because I think it's impossible to tell, looking at the statutes, how many, not in this case, but more generally, whether or not, how many cases are too few, whether or not they're going to succeed. If you could say, we know for certain that 99.9% of all the cases are going to fail, maybe then.
All right.
But you'll never know for certain.
Okay, so now we're at 99.
Right.
Okay. How about 90?
That's exactly my point.
No, but you conceded 99?
No, that's why I didn't concede 99.
Well, you didn't at first.
I said maybe.
Oh, maybe. Oh, maybe. Okay, all right.
But the reason that I don't want to concede 99 is because then you say, what about 90%? And the answer to that is the answer that Justice Scalia gave in the NMO case. If you think that too many cases are being excluded, go to Congress. Get Congress to enact a new statute.
Well, then
don't amend this statute.
Then we're magic words, right?
No. I can give you an example where the FSIA, Congress could provide a cause of action without explicitly abrogating the FSIA, and it should be abrogated under Kurtz. Let's say there was a spate of automobile accidents in some country or some region in the world where all the instrumentalities, all the automobile accidents were caused by foreign instrumentalities. And Congress enacted a statute. There was some ether going around in the Congress, and they forgot that the FSIA existed, which clearly isn't here. They were staring the FSIA in the face. But let's say they said there'll be a cause of action for any American national injured in an automobile accident that occurs in another country. That would be barred by 1605, that would be barred by the FSIA's tort exception, because it requires that the tort occur in the United States.
Mr. Lobel, isn't the real reason